The odor of marijuana is now an aroma of legality. The odor of cannabis emitting from a motor vehicle standing alone no longer provides a law enforcement officer with probable cause to believe that the vehicle contains evidence of a crime.
And meaning the odor of cannabis no longer passes the smell test. That is some of the arguments from earlier this year in front of the Illinois Supreme Court about a case concerning an individual pulled over for speeding. Cops smelled cannabis and then proceeded to conduct a search on that based on probable cause. Of course, the argument going all the way to the Illinois Supreme Court earlier this year in January, hearing that case. But on Thursday, they released this opinion that really sums it all up here. It says in January 2020, the use and possession of cannabis is presumptively lawful, subject to certain restrictions. And they say, we hold that the odor of burnt cannabis alone is insufficient to provide a probable cause for police officers to perform a warrantless search of a vehicle. So, meaning, if a cop smells raw cannabis or cannabis smoke, they can't use that as the only reason to be able to get into an individual's vehicle and search. So let's hear some of the arguments here. It's Illinois in Focus Daily. I'm Greg Bishop, and you, of course, can like, subscribe, hit that notification bell with America's Talking Network here on YouTube. Get Illinois in Focus Daily anywhere you get your podcasts, and let's get to it here in this short segment about the smell of cannabis no longer passing the smell test when it comes to traffic stops. Here's the Q&A with Justice O'Brien and some of the litigants in this particular case.
How does that play into the odor-proof container when the smell isn't coming from a container or coming from an object, but coming from the person himself?
And this is the response from the attorney representing the state.
Herself.
Sure. So it's important to distinguish the two cases here. One dealt with raw cannabis, in which there was certainly no testimony that the smell came from the person. The officer testified that it came from the car. The second case dealt with smoked cannabis, which I think is probably closer to your hypothetical, which also was not the testimony in this case here. The testimony here was that the officer in Mr. Redmond's case approached the vehicle.
But my question to you was, if it came from a person, if the smell was coming from a person as opposed to an object, how does that play into even the vehicle code, where there is no prohibition against having the smell on the person? So that isn't illegal itself. So how does that establish the probable cause to search?
Sure. So I think all of the acts prohibit the use of marijuana in a vehicle. And that someone smells like a vehicle is certainly one factor of the totality of the circumstances, that cannabis has been used recently, and if a person is traveling in a car, that it may lead a reasonable officer to suspect that the cannabis was used.
But your argument is
so again, just some of the questions here, and that was the attorney representing the state, and he really hammered home the issue of, while cannabis may be legal for medicinal and now recreational purposes, there are restrictions on where it can be consumed. You can't consume cannabis and be under the influence while you're driving. You can't have open cannabis container. It has to be in a sealed, odor-proof container. And I think that includes the vapes. So not just the raw cannabis flower. So here's more of the attorney for the state talking about those provisions in law and why they say that it allows for police officers to smell cannabis and then conduct a search.
Raw cannabis would lead a reasonable person to suspect a violation of the odor-proof requirement found in the vehicle code, because necessarily the smell of raw cannabis emitting from a vehicle is not being carried in an odor-proof container. It's obviously proof that there's cannabis in the vehicle, and then that you can smell it is indication that it's not being transferred or transported in an odor-proof container. There's no testimony that it is impossible to comply with the odor-proof requirement provision, and that's clearly not the legislature's belief, because they enacted the odor-proof requirement in 2019 at the exact same time that they put in place the now full legalization system.
So you've got the state laying out their case, and then you had the various individuals representing those who had their vehicles searched after a police officer smelled cannabis. And this particular attorney, Bruce what was his last name? Bruce Carmen. He laid out that, listen, probable cause is justified if the evidence that is used for finding probable cause is not subjective.
Olfactory senses aren't like the other senses. Stout came out of what is called the plain sense doctrine, which is you have to plainly sense, see, hear something for there to be probable cause. Smell is not like that. You can't take a picture of a smell like you can objects that you see in plain sight. You can't record on an audio a sound you might have heard, for example, someone showing evidence of impairment. Smell is entirely subjective. In fact, in this day and age, and I think I argued this in my brief, in the day and age of COVID...
And he goes on to say that people can't smell now because of COVID-19. The attorney representing the other client who was searched because of the smell of cannabis, James Martes, he laid out what he says is kind of a reiteration of what the other attorney had to say. It's not justifiable for a search.
The reason is because the detection of the olfactory senses, as Mr. Carmen argued, is highly subjective and variable. And so the smell alone without more is not sufficient. I gave the example of the strong smell of burnt cannabis coupled with smoke wafting out of the vehicle, or perhaps ashes burning in the vehicle. That would be additional circumstances that would go into the probable cause calculus that might establish probable cause. But the smell alone simply can't be a basis for a search.
And he wraps up saying that this is a bottom line issue of constitutional rights and whether somebody gives up their constitutional rights in order to exercise rights elsewhere.
To deny the motion to suppress would place a citizen in the untenable position of exercising his rights under the Cannabis Regulation and Tax Act while forfeiting his rights under the Fourth Amendment of the United States Constitution and Article 1, Section 6 of the Illinois Constitution.
And ultimately, what did the Illinois Supreme Court rule? Again, we'll go to their conclusion issued on Thursday. They said in sum, the use and possession of cannabis is presumptively lawful, subject to certain restrictions, and we hold that the odor of burnt cannabis alone is insufficient to provide probable cause for police officers to perform a warrantless search on a vehicle. Pretty fascinating stuff, but of course, we'll bring you even more of it as we get it here with Illinois in Focus Daily. Like, subscribe, hit that notification bell, and join us for the live program each and every weekday morning at 8 o'clock. But you can also get the podcast anywhere you get podcasts. Just search Illinois in Focus Daily.